All right. I think we're ready to call the case now. Thanks for bearing with us, folks. Mr. Walter is here in person representing the petitioner, and if I could have appearances from other counsel.
Good morning, Your Honor. This is Thomas Kinzinger with the California Department of Justice here on behalf of the State Lands Commission and Coastal Commission.
And good morning, Your Honor. Eric Katz on behalf of the California State Water Resources Control Board.
Good morning, Your Honor. Joseph Drapolsky on behalf of Invenergy California Offshore LLC.
Good morning, Your Honor. Charity Schuller on behalf of Real Party and Interest Atlas Wind, aka Equinor.
Good morning, Your Honor. Julie Jones of Perkins Coie on behalf of Golden State Wind, Real Party and Interest.
Good morning, Your Honor. Alina Shamos with Burke Williams and Sorensen on behalf of CSA Ocean Sciences, Real Party and Interest.
All right. Thank you, counsel. So we're here for the case management conference. I see that there is the notice of appeal that's been filed on the ruling on the request for preliminary injunction. And I just wanted to check in to see what's happening or what your plan is with respect to the underlying petition while the preliminary injunction ruling is up on appeal. If you don't mind just pulling that microphone closer to you and speaking right into it, Mr. Walter.
Yeah, thank you very much. I would think that that's a very discrete issue for the Court of Appeal. It's one that's in, I think, everyone's best interest to get a resolution on early through this planning process and the processes that are proceeding. I would think that the various preparations for the administrative record should continue. I think those are fairly discrete items. I think this case tries to bring together the common issues that would be involved in all aspects, crossing the different parties. But I think we should be able to proceed with getting some progress, I hope, on the administrative records and then proceeding from there. I would like an opportunity to, because it's kind of a moving target, so to speak. There's always things that happen. If they're related to issues that are already within the case, then my feeling is they should come into this case for the economies of deciding the parallel issues at the same time. So I would need to amend the petition another time concerning the federal water surveys that have been approved on July 2nd for Golden State Wind. And there's the last amendment brought in Equinor's processes in that regard. And this would be a parallel, the same issues, different applications, but the same basic legal question.
All right, let me check in to see how the preparation of the administrative record is coming. I'm not sure who would be best to speak to that.
I can speak for State Lands Commission and Coastal Commission, Your Honor. The Coastal Commission's position is that there is no administrative record for this case. It has taken no action. So that would be a Coastal Commission. As far as State Lands Commission, they believe the administrative record is discrete and limited and should not take long to prepare.
Okay.
And Your Honor, Eric Katz for the State Water Resources Control Board. Similarly, the State Board does have an administrative record for its relatively discrete decision. The State Board is looking at it. The record won't be very large, and so don't think it will take too long to prepare. But we are also considering whether to file a demur to the existing first amended petition, which of course doesn't need we don't need to wait for the record to be prepared to file that, although my understanding is there's a stipulation in the case confirming that responsive pleadings aren't due until 30 days after the record is prepared. But to the extent we decide we'd like to proceed with a demur, following any meet and confer, we'd expect to file that demur in advance of certifying the record.
Okay. Thank you for that information. Any update from other council?
Your Honor, this is Joseph Trapolsky with Invenergy. The only question that I would pose is, do we have any estimated timetable, Mr. Walters, on when you would amend the petition? Because that might also affect the party's decisions regarding a demur, motion to strike, or other attempt at pleading.
I would think if I could, 3 weeks.
Okay. So the question, I guess, would be if there's an objection to petitioner filing an amended petition by anybody.
Your Honor, that's speaking on behalf of Invenergy. That's somewhat of a complicated question, given the limited information that I've at least heard about what might be contained in that amended petition. I believe I heard plaintiff's counsel mention that it would include issues concerning federal waters, and I believe it was Golden State Wind survey activities in federal waters. Your Honor, as we discussed in our past appearances before this court, the inclusion of federal waters might significantly alter the landscape of this case. And that's something that we would need to think over and probably see in the amended petition before we could decide how to respond.
So it sounds like that would need to proceed by way of motion on the law and motion calendar. Mr. Walter.
Well, or in a sense, it might be easier just to have it there. And then they could make a judgment as to how that alters the landscape. I see it as a state issue, a state law issue in terms of actions by the Coastal Commission, in terms of signing off on those surveys. And the court, I think, has jurisdiction over the Coastal Commission. My only reason I suggested is it might be easier to look at the pleading rather than to speculate about the pleading, and they'd have an appropriate opportunity to respond and reply.
Right. So whether we can accept it as filed would depend on filing a motion to amend. And that would get set on the law and motion calendar. Of course, you're free to meet and confer with counsel before the hearing date. And if there's no objection, then there would be no need to go forward with briefing and any hearing on it. But if folks aren't willing to stipulate to allowing filing of a First Amendment petition at this time, then that's the route we're going to have to go.
All right. Thank you.
Okay. So when does it make sense to come back then, given these different moving parts? I mean, it sounds like the administrative record is actually not a rate limiting step. It's more settling the pleadings and whether there's going to be any demurs or motions to strike, et cetera. And that might take some time if we're going to have a discussion about whether a First Amendment petition will be filed or an amended petition will be filed. So does 90 days make sense? 120 days? Just to let you know, we are setting things on our law and motion calendar at this point into October and November, if it's going to be a fully litigated motion.
I would think, I suppose if the State Lands Commission is going to be able to complete their record sooner than later, then we can probably just coordinate that and determine the appropriate timing without having to come back just to report on that. So we should be able to resolve that issue. So I would suppose October.
Okay. How about late October, early November? Does that work for folks? I'm
Your
seeing
Honor.
that- Yeah, Mr. Drapolsky, go ahead.
Yeah, I apologize for interrupting. So is the question of when a hearing on his motion for leave to amend the petition would be heard?
Well, no, I can't set that today. I don't have the law and motion calendar in front of me. I'm sort of just generally telling you those are being set, I think at this point, late October, November. What I'm going to be setting today is further case management.
Okay.
What we could do is set it mid to late November or even into December and advance the case management date if the to the hearing on the motion for leave to amend, if that's set earlier.
I think that makes sense, Your Honor.
Okay, so why don't we set further CMC on December 4 with the understanding that that date would be advanced if a date for a hearing on the motion for leave to amend is set earlier than that.
All right.
Okay. And Mr. Katz, did you have anything to add? I see you're about to talk.
Yes, thank you, Your Honor. I have a slight concern about the state board proceeding to prepare the administrative record based on the allegations in the first amended petition. That's the operative petition. If the allegations are going to change. And so I guess just to be transparent to the court and the petitioner, it makes sense to me for us to pause preparing the record until we at least see the proposed second amended petition. It doesn't sound like there's any new allegations being proposed related to the State Water Resources Control Board. But if there are, that, would presumably entail, a different record if there's some other decision that's being challenged. I don't believe there's any State Water Board decision other than the one alleged in the operative petition, but I don't know if the petitioner can shed any light on that. If the proposed second amended petition is totally unrelated to the State Water Board, we can just continue to proceed.
Mr. Walter?
I don't see anything that would be additional, with the caveat that the approval that the Water Resources Control Board gave is related to another administrative process happening on Friday before the Coastal Commission. The only thing that I could see that would happen as a result of that is it could moot. It's possibly moots the approval by the Water Board. But we'll have a better idea on Friday.
But the question is whether there'd be anything in the second amended petition that would involve a different decision by the State Water Control Board.
Nothing that would be additional. The only change that might occur is it could become moot.
Okay. And Mr. Katz, there's only been one decision by your client in this regard, correct?
Correct.
Yeah, so then I would say go ahead and just prepare the administrative record for that decision.
Okay.
Okay. So December 4, 9 a.m. for further CMC and notices waived?
Yes, Your Honor.
Yes, Your Honor.
Yes,
Yes,
sir.
Yes, Your Honor.
Yes, Your Honor.
And I'm
Very-
sorry to bring up one more thing, Your Honor.
Yeah, go ahead, Mr.
Could we
Drapolsky.
also just discuss timing of the amended petition? And because we're now talking about pushing things out a few months here.
I'm sorry, go ahead. Timing of the motion for leave to amend?
Yeah, of when Bill would file the motion. I mean, what are you thinking, Bill?
Well, I was thinking if I would just amend it, then it would be about 3 weeks. If I do the motion, then it would be probably 4 weeks.
So just to manage expectations, you would file the motion, serve the motion in about 4 weeks. And then if you could set the hearing for the soonest available, it sounds like October.
Yeah.
I don't know what soonest available will be when it's filed in August, but that's something that will be determined at that time.
Yeah, I don't think it even, as I understand it, when I file it, we won't even put a date on. The clerk will select the date.
The clerk will select the date and then you'll have to give notice of the hearing date. Right. I'm not sure if that helps, Mr. Rapolsky. So you got the timing in terms of filing, but not necessarily in terms of the hearing. So.
Right.
Okay.
Your Honor.
All right. So I'll see everybody on December 4, if not earlier.
Yes, Your Honor.
Thank you, Your Honor.
Thank you.
Thank
Thank
you.
you, Your Honor.
All right. And then let me just check in with folks here in court to see what cases you're here on. Okay, so I'll call that case next. The Charles Roberts versus State of Robert Patrick Rice matter. And if counsel can state their appearances, please.
Morning, Your Honor. Michael Chalupka for the plaintiffs.